Hello everybody and welcome to my channel. Go ahead, hit the like and share. Subscribe if you haven't already. This video I wanted to make because as I was watching Miss Phases and Dana and Blockbender and Levi, Miss Phases made a point, and I just wanted to dedicate this video to that. And she said she's not hearing many people talk about how R. Kelly's rights are being violated. So before I go into that, let's take a step back to this last hearing. And I just feel like at that hearing, people got more distracted by this so-called refund request that you may have missed a great detail in what was said. So let's just play it back.
Were set on the 4 cases. The court that was setting bond wasn't aware of all the other charges that have now since been filed, both in the Northern District here in Chicago, the Eastern District of New York, and then also up in Minnesota. And so I wanted to make the court aware that the defendant has now been charged with multiple additional sex counts in all these jurisdictions, and that should affect what the actual bond is being set in this case. And that wasn't known to the court when we did our bond here.
Okay. All right. Mr. Greenberg?
Judge, the first thing I would indicate, although it's not in our written motion, is it's not verified. There's no verified motion to increase bond, which the statute requires.
Okay.
The second thing is there's no legal basis that's such.
So he basically just told y'all that she's in here requesting this bond increase, and they ain't even submitted all the so-called evidence they have. But never mind that. They want to come in here and request a bond increase, but they ain't put in no paperwork for this. Number one.
By the prosecutors to increase the bond. The mere fact that someone may have been charged with other cases in other jurisdiction is not a basis to increase bond. It's not a basis under the statute. It's not a basis under the case law. They don't argue that he's an increased flight risk. They don't argue that he's an increased danger. They don't argue any reason in their motion why bond should be increased. The bond in those other matters has been addressed by the judges in those matters. As the court knows, he's being detained on both of the federal cases. We intend to ask the courts to reconsider those orders. We filed a motion in the Northern District, and we're filing a motion in the Eastern District of New York for that. Should the federal court modify those orders, I fully expect that he will be put on some kind of house arrest, electronic monitoring, GPS, or something like that, which also means that he's not a flight risk. He doesn't have a passport. He's not a danger to others. There's nothing in these other indictments or in these other allegations to show that he's a danger to others. All of the allegations predate these charges, predate the bringing of these charges by years and decades. I would point out also, Judge, that when the state added charges before Your Honor, they didn't ask that the bond be increased. The fact is that Mr. Kelly has never missed a court date, never missed one on this case, never missed one on the prior case that he had. Voluntarily turned himself in originally on these charges, voluntarily came to court when the charges were upgraded against him. And there's simply no legal basis to increase the bond in this case.
Any response?
I would just say that a lot of what counsel just said is based on speculation about what could happen if his bond were changed in one of the other courts. And so it's a lot of speculation. I would also point out that part of his charges here in the Northern District of Illinois include the fact that the defendant is accused of having influenced the witnesses on that case, that first trial. And lastly, I would say that the defendant does have additional charges, and that absolutely is appropriate to bring before this court to ask that his bond be increased. He does have additional charges.
Okay. All right. Look, as a practical matter.
And yet I still don't hear her mention he is a direct threat to the public. Now, if she's sitting here saying what he said in response to her is speculation. She over here in return wants to rebuttal with the speculation, saying that, well, it's being said that he paid off the witness or whatever, whatever. Well, even if that were the case, do you not think that that still could happen whether he's in jail or not? Like, again, I just see red flags when all you keep seeing is the victims keep handing their hands out. These attorneys keep having their hands out. The prosecutors keep having their hands out. All I keep seeing is money, money, money.
He's being held now, no bail, in the Eastern District of New York and in the Northern District of Illinois. Unless Mr. Greenberg can convince both of those courts that he should be released on bond, Mr. Kelly's going to remain in custody. So as far as a motion to increase the bond, I don't believe it's appropriate at this particular point in time. That being said, if there's a change in circumstances, in other words, if you're able to convince both of those federal courts in those different jurisdictions that he should be released on bond or some type of conditions regarding release, if you want to bring that motion to increase the bond back before the court, I think that would be appropriate. But at this particular time, it's kind of a moot point. The bond that was set originally in this matter by I'm assuming the bond court judge, or maybe from the grand jury, I'm not sure. Bond court? Okay. I thought when the case first came before me for arraignment that the bond was adequate based upon the fact that there's 4 cases. There's $250,000 D bond on each one of the cases, plus pretrial services, which I thought was appropriate based upon the information that I had regarding Mr. Kelly. I still believe that's true. That being said, I'm going to deny the motion at this particular point in time. If there's a change in circumstances and he is somehow released from custody and you want to bring it back before me, I'll take a look at it then. Okay? Along that, as long as we're talking about that, there was an order issued regarding pretrial services. In light of the fact that Mr. Kelly's in custody, I'm going to vacate that order here in Cook County. And then, like I said, we'll take a look at it again if he is released on bond. Okay? All right. The final issue I have regarding bond is a petition or a motion, rather, to intervene filed on behalf of the surety. And Mr. Collins, would you just identify yourself for the record?
Yes, my name is John Collins, JOHNCOLLINS, on behalf of the surety, requesting leave to intervene in this matter and present a motion to you, Your Honor.
All right, I'll give you the opportunity to file your motion and intervene for the limited purpose of arguing on behalf of the surety that you want the bond returned.
I don't know if counsel is ready to argue today, if they need a little time. I filed it Friday, so I do understand that they might have no time to respond. If not, I'm prepared to argue today.
Well, it seems to me, just looking at the motion, that the only response that the defendant may have is whether or not he wants to agree to exonerate the bond, which means that he would be held no bond.
And again, I understand that they are trying to petition in Northern District, Illinois, and in New York. However, Judge, the petitioner is in fear of jeopardy of losing this bond. Judge, as we understand, I think there may have been a CPR placed on this bond, and there's monies owed, so we want to try to stop before and let the court know at the earliest moment that we expect to receive these monies back.
Okay, the only question I have is what authority do you believe that the surety has to come in and request that I do that?
Well, Judge, there's been a substantial change in circumstances. Just like when there's a change in circumstances to increase the bond, Judge, in this instance, he's held no bond, so the purposes of the bond are frustrated in Illinois. And with that being said, Judge, the insured had no basis of knowledge for the additional investigations. It was for this purposes only. So if bond is to be frustrated and he's to be held no bond, then there's no need to have her money sitting in deposit. So if they want to have an opportunity to address that, maybe some modifications to the other jurisdictions' bonds. But this case, this money in these instances were expected to be for this purposes. With bond being frustrated, the court has
a different issue. You're asking on behalf of the surety that I return the bond money, and I'm asking you, by what authority are you asking that?
Judge, if bond is frustrated, or if the purposes of bond are not being met, then the court has an option at its discretion, Judge, to order the defendant held with no bond in this instance. If he's going to be held no bond in 2 other jurisdictions and have this bond here waiting, then the entire purposes of bond are frustrated, so we can actually let you exonerate it. It's allowable under the statute. If you want additional specific instances, we can provide those, Judge.
Well, let me ask you this. Your client,
Yes.
okay, is Miss Veronica Love. Is that correct?
Yes.
I'm sorry, Valencia Love.
Yes.
And she's the surety. She signed the bond slip, correct? Okay. And did she read the bond slip?
Yes.
She did.
Yes. As far as I understand.
All right. If you look at the bond slip, it's clearly stated under notice to person providing bail money other than the defendant. And there's 4 points.
Yes.
All right? And point 1 is I understand that the money that I have posted is for the bail for the defendant named in this bond in the above numbered case or cases. Okay? Paragraph 1. Paragraph 2. This is most important. Paragraph 2. I understand that even if the defendant follows all court orders, that this money may be ordered in the judge to pay for the defendant's attorney's fees, court costs, fines, fees, and restitution to the victim, and that I may lose all of my money. That's italicized for emphasis. Third, I understand that if the defendant fails to comply with the conditions reflected in the bond, I may lose all my money should the court enter the forfeiture of bail. Again, I may lose all my money.
Now let's just pause right there, because it was already proven that this lady was paid off with interest. So the fact that so many took the initiative to spend so much time stressing on this request instead of thinking from a logical aspect, and if they're continuously saying that he's going to be held with no bond, they're just trying to get that money back if it's going to be sitting, not being used. That's just what I saw from it. The lady came on her social media to clarify that she had been paid back. So, again, this is something I feel like a lot of people got distracted by. But let's go back to what they may have missed.
I still think sureties, and I can find the statute. I think sureties have a right to say if there's a change of circumstance or he doesn't comply with that, they can raise and say, hey, I'd like to have that money back. I don't think it's.
I'd like to see that because I've never run across that, and I think of what that implies. Think of what that implies. If what you're saying is true, the implications are that any person who posts the bond on behalf of another, all right, if they don't like what's going on with the defendant or the particular circumstances, they can come into a court and ask that the bond be exonerated because they feel that things aren't going the way that they thought that they would. That contradicts completely what's in the notice to the surety on the bond slip at the time that Ms. Love signed the bond slip.
When that bond slip was being signed in the halls of the Cook County Jail, I don't think that she took the time to have legal advice. I think that we can raise these issues, Judge, and the fact that there's any surety with a request on it doesn't like to change the way that the case is going. That's not the instance here.
What
frustrated, and it seems like it's going to be a big grab at it when it wasn't initially agreed upon. So if the court would like additional information present that. We can set it down for additional hearings where the court will be persuaded that.
I'm not going to go down that road right now. I'm going to deny your motion. I'm going to deny it. I don't believe that there's any basis for it, so it'll be denied. If you have anything else in the future you want to bring it, I'll take a look at it. But right now, you haven't really presented me with this.
Respond. You know, all we want is R. Kelly to be treated like everyone else. And so far he's being treated differently. There's been this rush to judgment. The facts are going to come out. They're going to start coming out. We've got all these people saying he's the worst criminal ever. He's not. When you look at the indictments, when you look at the evidence that they have, the allegations are old, they're stale, they're things he's been acquitted of.
You mentioned, I think you used the term voluminous amounts of documents in all these cases. What have you gotten so far?
Well,
How long is it taking you to get through all?
Well, it's going to take a long time to get through. We can't talk about what they've given us because there are protective orders in both of the federal cases. I can tell you just generally it consists of bank records, phone records, hotel records, travel records, a lot of music videos. I've learned a lot about his music that I didn't know. TV interviews, videos. Yeah, I've watched a lot of videos and stuff like that. There's very little in terms of any meat or substance standing of this. But the problem is, this all started with this documentary. And when you look at the documentary, it's all woe is me, and woe is me. When we start looking at the evidence, what we're finding out is that the documentary was a complete farce. We've got his ex-wife, Drea, who was on the documentary talking about how awful things were. We've got video of her showing up at his birthday party in 2015 in Atlanta, happy as can be. We've got information that the Clarys knew exactly what was going on. They claim they never met R. Kelly. We got pictures of them with R. Kelly. They knew exactly what was going on. We've got documentary evidence that people lied about their ages to R. Kelly. We've got essentially extortionists, people who were sent out to capitalize on him. So the truth's going to come out, and when the truth comes out, hopefully the public's going to give them a fair shot. They're going to listen, and they're going to realize that this is a witch hunt and nothing more.
Steve, can you talk about the bond that Valencia Love put up? What was decided today? What happens to that money right now?
So Valencia Love posted bond. She had some deal with R. Kelly where she was going to put up the bond money. I don't know what that deal is. It's not my business. But the judge is right. Someone who posts bond for a defendant can't come into court and say, well, now I'm upset with him for some reason, or something has changed. I want my money back. Just think about the practicalities of that. A girlfriend who posts bond for somebody, and then the person breaks up with them and they come back in. Or a parent who gets mad at their child or so forth. So the practicalities of it are that you can't come into court, and that's why you heard the lawyer saying, well, she's frustrated. She's frustrated. Well, that's on a legal basis. You know, a lot of us get frustrated. Okay?
Regarding the bond, I know you would not wanted to talk about how you were being paid. Is it possible if R. Kelly doesn't have the funds, which exactly that you might be paid out of what was put up for bond?
So I'm not going to talk about how I'm being paid or anyone else is being paid. We're working on the case. We're being paid to work on the case. We're doing what we have to do.
Is that common practice if the client does not have the funds that money posted for bond might go for attorney fees?
No, so in Cook County, in Illinois, money posted for bond can go for attorney's fees at the end of the case. It's not till the end of the case. I can assure you that we're not working hoping that at the end of the case we get bond money.
You are being paid.
We're what
I'm worried about your future. Are you being paid?
you sound like my children now. We're all being taken care of. We're all being compensated by Mr. Kelly, and that's really between us and Mr. Kelly. If Mr. Kelly reaches a point where he can't pay any lawyers to represent him, you'll see a public defender file an
So
appearance.
Valencia Love saying that she doesn't want her money going.
So we heard that. R. Kelly is paying them. Should he ever come to a point where he can't pay them, he will be using a public defender. So let's talk about R. Kelly's rights. because that's the most common topic being ignored. And I remember even in elementary, I was taught the First Amendment rights. So let's take a quick review of the top 3 that are being demonstrated in this case as a direct violation of his constitutional rights.
There's ones that you're probably familiar with. There's the freedom of religion. There's the freedom of speech. There's the freedom of the press. And then, of course, the last one, the freedom to peacefully assemble. Now, these First Amendment rights are not absolute, meaning you can't say whatever you want to, whenever you want to. You can't use threatening speech against somebody. And the freedom of the press is also limited. You can't use slander against somebody or intentionally smear their reputation to do them harm. And the idea of peacefully assemble, you cannot just get a group of people together. There's rules that you need to follow, but you do have a constitutional right to be.
So, your rights protect you from being slandered by the press. And yet, what do we see with R. Kelly every single day? Your rights protect you from having all these people organize and demonstrate and put a stop to your finances. But yet, what do we see with mute R. Kelly? We're gradually seeing a lot of this man's rights being stripped. Seems like hate groups to me. You all may know them as Me Too and Time's Up.
I mean, you're probably familiar with this idea called I Plead the Fifth, and I'm going to get to that in a second. But the first one I want to talk about is something called double jeopardy. And it states you cannot be tried for the same crime more than one time. Essentially, the government, if they feel they have a case against you and they take you to court, take you to trial, they have one opportunity to find you guilty. And if the jury or if the judge finds you innocent, that's it. They got one shot. They cannot continue to keep charging you over and over and over again until they try to get the guilty verdict. Double jeopardy. They got one shot at you, and that's all.
Is that what we're seeing with R. Kelly? Let me give you the prime example.
Second victim, initials RL. The second victim, initials years older victim, initials RL, was involved in an incident which occurred between September 26, 1998 and September 25, 2001. A grand jury occurred between September 26, 1998 and September 25, 2001. A grand jury returned an indictment on 2 counts of aggravated criminal sexual abuse based on the victims being under the age of 17 and Robert Kelly being more than 5 years older than that.
So, we just gonna bypass that she just included the second victim, initials RL, which is the same victim from R. Kelly's first trial. And of course, good old surviving R. Kelly tried to insinuate her and even throw up this picture to the left of another girl who was not Rashonda Landfair. But yet, to fit their narrative, they wanted to have a picture with R. Kelly and a child, so they used any child and made it seem this was Rashonda. At the end of the day, the person on the video in question was Lisa Van Allen, not Rashonda. So they have the wrong person. And to be retrying him for this same person, how is that not a clear case of double jeopardy. How is that not a clear case of violating his right? Period. The media, going back to the very first violation, it's not one thing to attack him, but once the so-called sex slaves and victims don't go along, oh, now they're in hot water, according to the media. Isn't it funny how they 1 minute go to brainwashed sex slaves to now they're possibly facing prosecution? For what? As Mr. Greenberg pointed out, this is a clear case of extortion. Going back to the first trial, since they wanted to bring it back up, let's talk about it. You're going to have the stalker from the first trial who linked up with the same attorney who's been making a career suing R. Kelly, or at least reaching settlements with R. Kelly. It seems like to me, if people are not recognizing the clear signs of extortion being run by these people now claiming to be victims, you're clearly blind. And why is R. Kelly being treated less than a dog? This man has not been convicted of any crime, and yet all of his rights have basically been stripped away from him. Let's go to the last one that I wanted to point out before I close this video.
You do have rights. If you're accused of a crime and you're taken to court, you do have rights. Now, the first one is you have a right to a speedy and public trial. So that trial has to happen in a speedy. Now, that's a little bit of a sloshy term, but they can't just throw you in jail and let you sit there for 10 years without giving you a trial or a trial date. And that can be a public trial so everybody can see. You do have the right as a defendant to decide if you want your guilt or innocence to be determined by a jury or to be determined by a judge. And you can also question witnesses against you at trial. So if there are people that are coming at your trial and testifying against you, you have a right, or your attorney has a right, to question those witnesses. And the last.
So that was the reason why I wanted to hit on this one. It's not the only one, because these three that I'm talking about are just the main ones. But let's not get it twisted. All of his rights are being violated. But part of this Sixth Amendment, if you hadn't noticed with this case, they want to now try to make these victims anonymous. With that being said, you would think with them being anonymous, they wouldn't have to testify. See, it would be easy to sit here and use the press to make all these accusations and then want to hide behind a Jane Doe number 1 or Jane Doe number 2. How will that give him the fairness of being able to question the witnesses making these accusations against him? Now, as Spitting Fire and Dana J and so many other people have pointed out, shout out Levi for Kelly, shout out T. Stevens, Sky Zone, everybody in the crew, Sugar and Spice. You know I love my Sugar and Spice. But as everybody is trying to push through to everyone, this is not solely about R. Kelly. if we continue to stand by and be silent and turn a blind eye to injustice, it's only a matter of time before it'll be your brother, your son, your cousin, your father, your dad, anybody that could have possibly wronged somebody can now be an abuser. Just think on that. Shout out to everybody supporting the channel. Have a great night.